Good morning. It's 10 a.m. on Tuesday, November 12th, 2024, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I'd like to bring to your attention there is a sign-in sheet on the table by the door. And for anyone that would like to make comments about an agenda item, please indicate so by your name as you sign in. Public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you please call the roll?
Don Haynes.
Here.
Chris Lee.
Here.
Randy Nash.
Here.
Wendell Naylor.
Here.
Scotty Porsche. Pam Stevens.
Here.
Tim Willer.
Here.
Ms. President, we have a quorum.
Thank you, Ms. Bohannon. At this time, I will entertain a motion to adopt today's agenda.
So moved.
You have a first by Mr. Lee, a second by Mr. Naylor. Any discussion? All in favor, say aye. Aye. Any opposed? Okay, motion approved. You were submitted with your paperwork the approval of the minutes from our October the 8th meeting, and I will entertain a motion to approve those minutes.
So move.
Mr. Wheeler with a motion, Mr. Naylor with a second. Any discussion?
Madam President?
Yes.
Found a mistake
Okay.
in the minutes.
Mr. Nash?
Trying to find
You
it.
have the floor?
I'm sorry.
No. Good. Means you read them. What did you find?
On the, one more time here.
It's okay.
Nope, it's corrected. I'm sorry.
It got corrected?
Yep, I'm sorry.
Okay, again, there's a motion on the floor by Mr. Wheeler, a second by Mr. Naylor. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion passed. Mr. Bryant, if you would proceed with our legal report. We appreciate you so very much.
Thank you, Ms. Stevens, and good morning, board members. First complaints, three complaints that go together, same set of facts and circumstances. Those are complaint number 2024-037441, 2024-037471, and 2024-037441. And those are represented by the first complaint against the funeral establishment, the second against the funeral director's license, and the third against the respondent's embalmer's license. This complaint was opened following an email from an employee of the Department of Health Vital Records Division. Respondent funeral establishment had 6 death certificates in their queue that had not been released. The individual listed as respondent is the manager of respondent establishment. Respondent stated that they disagreed with the complaint, but then stated that the deficiencies identified in the complaint had since been corrected. As of November 1st, 2024, complainant stated that respondents only had 2 remaining in their queue and described it as, quote, much better. Respondent did not respond to the complaint within the time required by applicable rules. Based on the above, we would recommend a $1,500 civil penalty assessed against the funeral establishment license, a $1,500 civil penalty assessed against the funeral director's license, and a $1,000 civil penalty assessed against the embalmer's license.
Thank you, Mr. Bryant. Does anyone have any questions or comments regarding this?
Mr. Bryant, how long were the death certificates in the queue that were being held?
I can double check that real quick. From what I am seeing here from the screenshot that was taken along with the complaint that the employee of the Department of Health sent in, we have one from July 23rd, 2022, one from November 16th, 2023, one from January 4th, 2024, one from February 1st, 2024, one from May 18th, 2024, and then one from June 23rd, 2024. And just for full context and information, it appears this complaint was filed, or the email that led to the complaint was sent to us on July 5th of 2024.
Do we know which 2 death certificates are still remaining outstanding?
Unfortunately, when I reached out to complaint and they didn't provide that, it is also possible, can't say for certain, that the respondent fixed the 6 and then had a new 2. I'm not entirely sure, but the complainant seemed happy with the progress, at least, which is at least somewhat encouraging.
Did the respondent give a reason for not responding when you spoke to him?
They did not, no. One thing I will, if the board's had a chance to look ahead, there are several on here that have that. What usually happens whenever we don't get a response is, I honestly would even say 99 out of 100 times, 100% of the time, I reach out because I know if we get to this step and there's not a response, that puts the board in a very difficult position where we don't have each side of the story. So when that happens, I reach out. And with this one, a response came in, I would say, at the 11th hour, 59th minute. And I had followed up trying to get a response and was thankful that we got one. But they did not explain specifically why they had not replied within the time required. And the reason we have so many of those on this legal report today is that at some point, just got to move them forward. And I'm happy to bend over backwards, do everything I can to try and get you all the full picture and information, but sometimes they just have to go.
Mr. Bryant, how much time is allowed for someone to respond?
That is a great question. So the way it usually works is when a response or a complaint is received, we send it to them, and they have a 2-week window in which to respond. Technically speaking, if a response comes in on day 15, you're late. The rules articulate late responses. Again, I think if one came in on the 15th day and they said, I'm so sorry, it went to my junk mail or whatever, that's totally fine. So you do get a 2-week window, and then if you haven't responded, I'm probably going to be calling to bug you to try and get a response in.
Based on history, this funeral establishment also had that same issue. I guess that was in 2021, a delay of filing multiple death certificates. So there is a pattern here.
There's also a pattern on the next page of them not responding to complaints as well.
I make a motion to approve.
Second.
There's a motion by Mr. Nash, a second by Mr. Wheeler. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion passed.
The next 2 complaints are complaint number 2024-037901 against the funeral establishment license, and complaint number 2024-037921 against the funeral director's license. This complaint was opened following an email from an employee of the Department of Health Vital Records Division. Respondent funeral establishment had 4 death certificates in their queue that had not been released. The individual listed as respondent is the manager of respondent establishment, and respondents did not respond to the complaint. In a communication with complainant on November 1st, 2024, respondent had lowered the outstanding death certificates in their queue to 1. Based on the above, we would recommend a $2,000 civil penalty assessed against the funeral establishment license and a $1,500 penalty assessed against the funeral director's license.
Any questions for Mr. Bryant?
Mr. Bryant, I see, and previously we have had to send it to collections where they've had, so have collections been able to get the money from the previous?
That is a good question that unfortunately I don't know the answer to. I know that we kind of have 2 flavors of collections. One, if it is over $10,000, it goes to the Attorney General's office for collection. They have a specific division there. And then we have anything under that, it just, I think, goes to your regular normal collections. it's a little easier to follow up on the first one since we have a contact over there that I can just send an email or anything like that. As far as whether that one specifically was collected, I unfortunately don't know that for sure, and I apologize, I don't have that information.
What's the time frame for them to either pay the penalty or ask for a hearing? Or is that something that down the road, the board will be made aware of if we need to go further and maybe do something with their license if they don't respond to? I'm guessing they still have not responded to this complaint.
They have not, no. So, yes, the board will be made aware that if it does move towards a formal hearing, I'll essentially set up the work on that front end, get a date and hearing scheduled, and then, of course, we'll apprise the board of that whenever that is upcoming. So at this time, they have not responded to it. Essentially, what I think the plan on this one is obviously pending the board's decision on this one, what we decide to do, we'll send out the consent order and then just follow through that if they don't sign or don't agree to move forward in that manner, then next up would be a hearing in which, again, we'll go through that process. I will certainly let the board know before the hearing date.
And last question for me, the penalties for the funeral establishment and the funeral directors, that based on the complaint, or has the failing to respond to the complaint been added into that figure?
It has been added. I know typically what the board has historically done is that for failing to respond, it's, I think more recently we've done $1,000 for failing to respond. So this is based on the complaint of failing to release those certified death certificates from the queue, which again, I am relieved that the complainant has said that it has gotten better on this one as well. That's good. But the recommended civil penalty is for having those, not releasing them initially, and for failing to respond timely.
As far as recommendations, so when we take your recommendation on a penalty, can the hearing, is it automatically has to be, you authorize them to choose a hearing if they would like, or can the recommendation be a hearing? Since this case, it's been turned into a collection and seems likely the penalties won't get paid again.
So,
Does that make sense?
Yes, it does. So I will say that I would say probably 99.99% of the time, just going straight for the hearing probably is not the ideal, because again, if they agree to it and we can settle it via consent order, then we're in great shape there. I will say that Mr. Gribble and I have discussed this matter, I would say, pretty extensively leading up to this board meeting. We do have a plan of how to kind of take a half intermediate step. Unfortunately, I have to be a little vague. I can't share all of that, but we do have a plan for how to move forward on this to where it won't just end up in collections.
The only reason I ask that is number one, from things going to collection, but number two, there's a pretty extensive history. So,
Great.
all right, thank you for your answer.
And part of that plan that we've discussed is in the consent order. Normally, you can just send a normal check along with the consent order, and that's perfectly fine. But to avoid that issue as well, we plan on requiring in the consent order to pay via cashier's check, something we can just make certain. And one thing I will add as well, if questions about hearings and things like that. So if the board agrees that a recommendation, we'll take this for example. I send the consent order out for $2,000 for the funeral establishment, $1,500 from the funeral director. Doesn't pay it, doesn't agree to it, whatever that may be, and we do move forward with the hearing. What the board recommends here is for settlement in lieu of a hearing. So if we go to a hearing, the board is in no way, shape, or form married to these figures that are recommended in the consent order. That is essentially on the front end of, hey, we could take you to a hearing. Here's what the board has agreed. We'll take care of it now on the front end. But if we go to a hearing, then essentially that's an offer, and that offer is no longer on the table.
Thank you. I'm the one that said that to you guys this morning. We have a motion on the floor by Mr. Nash, second by Mr. Naylor. Any other discussion? All in favor, say aye. Any opposed? Motion carried.
The next complaint is complaint number 2024-051421. This case was administratively opened following a routine inspection conducted on July 23, 2024. During the course of this routine inspection, the inspector observed the following. An employee for respondent establishment permitted their funeral director and embalmers licenses to expire on June 30th and did not reinstate the license until August 12, 2024. During this time, no information was found to suggest the employee acted as a licensed funeral director, but did find evidence that the employee had embalmed 7 decedents during this unlicensed period. Respondent replied, stating that the employee was unaware their license had expired and continued to embalm during the unlicensed period. Respondent stated that the employee is going through a divorce and their renewal notice came to their former address. Respondent stated the employee's ex-wife did not forward the mail to the employee, and thus the employee did not receive the notice regarding the expiration of licensure. Respondent stated that as soon as the employee became aware of the lapse, the employee renewed the licenses. Based on the above, we would recommend a $500 civil penalty authorized via consent order and a formal hearing if necessary.
Are there any questions?
Motion to accept council's recommendation.
Second.
I have a motion on the floor by Mr. Lee, a second by Mr. Wheeler. Any other discussion? All in favor say aye. Aye. Any opposed? Again, this board would like to encourage people to put these renewals on your calendar, and it is your personal responsibility to renew your license. Mr. Bryant.
The next complaint is complaint number 2024-051431. This case was administratively opened following a routine inspection conducted on July 23, 2024. During the course of this routine inspection, the inspector observed the following. Respondent is the employee from the preceding complaint who allowed their funeral director and embalmer's licenses to expire on June 30th, 2024, and did not reinstate until August 12, 2024. Respondent embalmed 7 decedents during the unlicensed period. Respondent's reply was virtually identical to the preceding, stating they did not receive the notice since it was sent to his old address and the mail was not forwarded to him. Respondent also provided that they had overlooked the email notifications as they were sent to junk files. Based on the above, we would recommend a letter of warning.
Any questions? I have one. Why is the embalmer not getting a penalty when the funeral establishment? Is this the same connected?
It is, yes.
So why would the embalmer not be penalized?
This is one that whenever drafting it was a close one, was a close recommendation of that. I know what historically we've done lately, especially with how many of these we've had. The establishment gets the civil penalty, and then the individual, assuming no disciplinary history or issues, especially similar to this, would get a letter of warning. This is one that I think is a little higher than we've seen sometimes of, we've seen 2 weeks, we've seen 3 weeks, 4 weeks. This one was about 6 weeks, it seems, and they involved 7 decedents during that time. So this was candidly, this is a very close one for me. If the board feels more comfortable with a civil penalty of $250, absolutely zero objections to that.
I'll make a motion to make it $250.
Second.
There's a motion on the floor by Mr. Haynes to increase to have a penalty of $250. A second by Mr. Wheeler. Any other questions, comments? All in favor say aye.
Aye.
Any opposed? Motion carries.
Next complaint is complaint number 2024-048371. This case was administratively opened following a routine inspection conducted on August 15, 2024. During the course of this routine inspection, the inspector observed the following. Respondent's embalmer's license had expired on April 30th, 2024. It was not reinstated until August 9th, 2024. During the unlicensed period, a respondent was listed as the embalmer on 1 death certificate. Respondent stated that during the time of the inspection, their license was valid, and respondent stated they did not purposely embalm any decedent without valid licensure. Respondent did not respond to the complaint within the time required by applicable rules. So based on the above, we would recommend a $1,500 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions or comments for Mr. Bryant?
I make a motion, we accept council's recommendation.
Have a motion on the floor by Mr. Wheeler, a second by Mr. Naylor. Any other comments? All in favor, say aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-040151. Complainant stated they contacted respondent on June 24th, 2024, inquiring about a death certificate. Complainant stated that the respondent implied it would not be available until 2 weeks after the decedent had passed, but that the decedent had passed away on June 3rd, 2024, and thus was already more than 2 weeks past the decedent's day of death. Complainant stated now respondent is not returning their calls, and they have yet to receive the decedent's ashes, death certificate, and personal belongings. Respondent did not respond to the complaint. Legal spoke with complainant on November 7th, 2024, and confirmed that respondent has still not provided the decedent's ashes, death certificates, or personal belongings. Legal has attempted to contact respondent, but has been made aware that respondent is experiencing health issues that require respondent to be out of the office regularly. And just for the board's and more context information on that, I essentially have a reminder on my calendar to ping me every 2 days, and I'm calling and just trying to get in touch with the respondent on behalf of complainant for that. So based on the above, we'd recommend a $3,000 civil penalty authorized via consent order and a formal hearing if necessary.
Mr. Bryant, can I ask how you came about with the $3,000?
Yes. So essentially, we have an issue for failing to respond to the complaint and of the failing to return phone calls to the decedent, or to the complainant, and just keep them informed about any delay or any issue, and then the issue of not returning the items to complainant. In that sense, I started with a $1,000 civil penalty for each issue, essentially. But again, as always, if the board has reservations about that number, be it higher or lower, more than happy to do what the board feels is necessary.
Do you know how many times you've called that they've been out of the office, quote, with their health issues?
So I have called, I would say, I started trying to get in touch on behalf of complainant just starting November 7th. So I've made 2 calls at this point. We did have the holiday yesterday, didn't have an opportunity to do so, and got a reminder on my calendar pinging me right now to give a call after this board meeting. So that would be number 3.
Mr. Bryant, when you call, do you leave a return telephone number?
When I call this respondent, and get a voicemail, I am told that the voicemail box is full and that I cannot leave a message. So that is part of the aggressive strategy of calling every couple of days that I know I should pop up on caller ID. I call from my direct line, and I would say very good about answering and returning calls when I get them. So they should have my number, but I'm not able to leave a voicemail.
Madam President, I make a motion that we approve the recommendation.
There's a motion on the floor by Mr. Naylor,
Second.
second by Mr. Lee. Any other questions or comments? All in favor, say aye. Aye. Any opposed? Motion passed.
Next complaint is complaint number 2024-040561. Complainant, mother of decedent, stated that they paid for a headstone on September 9th, 2023, and was told that it would be placed in approximately 90 days. Complainant stated that after 11 months, the headstone had still not been placed and claimed that respondent had been dishonest regarding the headstone. Respondent replied stating that the matter had been resolved as complainant had been issued a full refund. Complainant stated that the headstone company was not able to produce the headstone within a reasonable time, and thus a refund was processed. Respondent did not respond to the complaint within the time required by applicable rules. Legal spoke to complainant on November 6, 2024 to receive an update on the complaint. Complainant stated and confirmed that they had now received a refund from respondent, but that the refund was only received after the complaint was filed. Based on the above, we would recommend a $1,000 civil penalty authorized via consent order and a formal hearing if necessary.
When you spoke to the complainant, did they seem happy with the resolution that was reached, even though they've now gone a year and they have no headstone?
They still seem very frustrated by the delay. The complainant and I did have a conversation of, I know that even now coming off of the pandemic in 2020, I know that the headstone industry was one that was hit very heavily with supply delays. And I did explain that to them, but also said, you being frustrated and upset is 100% valid, and I'm more just trying to provide information and context. They did seem happy to have the refund. They made sure to let me know that the refund did not come until a complaint was filed, but seemed still frustrated by the delay, but happy that they got the refund now that they can at least move forward somewhere else and hopefully get a headstone down sooner.
I know there's a fine line between the funeral director part of it and the burial part of it. So is the funeral director being fined because they ordered the headstone?
So this was one we discussed, Mr. Gribble and I, if this would be more appropriate for a cemetery complaint. And I think where we ended up is that I think there arguably could be communication issues that the respondent had with complainant, but that could be just reading something into it. Ironically, the reason for the $1,000 complaint is that we didn't get a response within the reasonable time. And if a response had come in explaining all of that, this could have been a closure, this could have been a letter of warning.
Right. Thank you for the clarification. Are there any other questions?
Motion to accept council's recommendation.
Second.
I have a motion on the floor by Mr. Lee, a second by Mr. Naylor. Any other discussion?
Ms. Nash, I think.
Oh, Mr. Haynes?
Oh, Haynes?
Y'all are going to have to speak up a little bit clearer for me. I know. So, Mr. Nash, thank you, Mr. Naylor, for clarifying that. So there's a motion on the floor by Mr. Lee, a second by Mr. Nash. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-048451. Complainant stated that they became aware that respondent establishment had circulated a business card and advertised via their storefront prior to licensure. Respondent establishment has made application to the board, but not yet been approved. However, complainant stated that they had advertised prior to being approved for licensure. Respondent stated that on August 24th, 2024, they resigned from their previous employment and spoke with the general manager upon their resignation. The owner of respondent establishment stated that they and the general manager had worked together for the entirety of their career and that they had become friends. The owner explained that the general manager inquired as to what their next career steps were. The owner stated he provided the general manager the business card that had been made and that the general manager, quote, promptly stuck it in their pocket, which became the card presented in the complaint, end quote. The owner stated that they were at no point attempting to solicit business or future business by showing the general manager, their friend of 11 years, the business card. The owner also provided a time, date, stamped picture of their prospective location of their future establishment. The photographs do not show the installation of any signage or representation of a funeral establishment. The building still contains the signage of the previous business in that storefront. Based on the above, though respondent's intent may not have been to solicit business prior to licensure, the circulation of a business card, formally or informally, is a violation of the applicable rules and statutes. In order to circulate any form of advertisement material, again, formally or informally, with the intent to solicit business or not, the establishment must be licensed in order to do that. So based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Question to Mr. Bryant. Is the complainant the general manager mentioned in this report? Oh, is the complainant the general manager?
The complainant is not the general manager.
I'm having issues with the term circulation.
Sure.
Something that is circulated to me means something that is done publicly. Handing a business card to a friend privately, I'm not sure I consider to be circulation.
Sure, and I think that's a totally fair interpretation and reading of that. This is another one, I will be more than candid with the board, that was a very close call for me as to whether I think a little bit of it comes into, I guess, kind of spirit of the law versus letter of the law, and that I think a strict letter of the law reading, having the business cards, even presenting them to someone can under the strict reading and of letter of the law, I think would arguably be a violation. Though I 100% understand your point as well that, putting a little bit pressure of what does circulation actually mean. So I think that's an excellent point.
In view of the fact that there's no complaint history, I would recommend a letter of warning. I'll make that a motion.
There is a motion on the floor for a letter of warning and not the $250 civil penalty by Mr. Haynes.
In this case, I agree with Mr. Haynes's understanding of that. And even though you're not, I don't think he was advertised. I think it was two friends talking and somebody's feelings got hurt. I'll second that motion for a letter of warning.
Have a second by Mr. Lee. I do have a comment. This has come up many, many times in the past. Years ago, it was a lot of complaints about that, even before me being on this board. Friends or not friends, it is the law. It is the law. So there is a motion on the floor by Mr. Haynes, a second by Mr. Lee. Any other discussion?
I've got a question. So this individual has applied for licensure, correct?
Correct.
And will this, Mr. Gribble, you might have to answer this, but will this affect or this be placed in when we hear this this application? Will this be part of that?
So as far as, I guess, the application process, the complaint and the application essentially stand alone. That I guess the complaint should be looked at on its own 2 feet, and the application for licensure should be looked at its own 2 feet. So this complaint will not be associated with the application process, essentially.
I understand that's two different things. I guess I understand. Okay.
Any other discussion? There's a motion on the floor by Mr. Haynes, a second by Mr. Lee to change the civil penalty to a letter of warning. All in favor, say aye.
Aye.
Any opposed?
No.
No. I mean, aye. I oppose.
I oppose.
So we have 3 noes. Ms. Bohannon, would you do a roll call, please?
Mr. Haynes,
Yes.
Chris Lee,
Yes.
Randy Nash,
No.
Wendell Naylor,
Yes.
Pam Stevens,
No.
Tim Willer,
No.
So I've been here a little over 3 years, and this is my first tie. So I will.
Of course, it's under my direction here.
Make it interesting.
So if don't we do this? If we'll just hang tight for a second, I can pull up the law and then I'll read it. And if that changes anyone's mind or if anyone has any questions, get me thinking about them now and we'll get that moving.
Mr. Gribble, Mr. Bryant, we'd like to call a recess and take a little break, just for a minute. You can't stop it. Mr. Nash, you may be excused. We'd like to continue our meeting after the recess. Mr. Bryant, could you continue on?
Yes. So I think we have two pieces that kind of in tandem work together here. It's a little unusual that this pops up for someone that isn't licensed yet. So I think the two controlling pieces of law here is 62-5-309B. It is unlawful for any person, partnership, firm, association, or corporation not licensed as provided in this chapter to engage in the operation of a funeral establishment. So the next step and next question there to be answered is what constitutes operation of a funeral establishment? Is the creation and production of advertising materials and, again, I guess formally or informally, giving that to an individual considered to be the operation of a funeral establishment. I would say that's up to the board's determination. The next piece of information that is pertinent in this is in Rule 0660-01-.03 under changes. Under Section 2, a licensee shall not permit any advertisement, price list, brochure, business card, signage, internet website, or other written medium that is likely to be viewed by the public to refer to the funeral establishment by any name other than the exact name listed on the establishment application approved by the board. At this stage, there is no application that has yet been approved by the board. So the again, reading that, shall not permit any advertisement, which the business card is the important one here, that is likely to be viewed by the public to refer to the funeral establishment by any name other than the exact name listed on the establishment application approved by the board. There is not yet an approved application. So in theory, I think a very strict reading of that rule is that business cards can't be created with a name that has not yet been approved. If one hasn't been approved, business cards can't be created. And that isn't a problem, I guess, if you have them made, stick them in a drawer, and never touch them until you're approved. But in this instance where we have one that the card was made, it did one manage to get out, whether the intent was to solicit business or not. It did have a name of an establishment that had not yet been approved.
I don't agree with that, but with the strict interpretation of the law, I will withdraw my motion to do a letter of warning and reinstate the $250 penalty.
There's a motion on the floor by Mr. Haynes
I'll second the motion again since I did the first time.
to reinstate the $250 civil penalty. Any other discussion?
Here I am. When was this complaint filed?
1 second, I can get that for you. This was filed August 30th of 2024.
Thank you.
And the establishment license still hasn't come up for approval yet, is that correct?
That is correct, yes.
Okay.
There's a motion on the floor by Mr. Haynes, second by Mr. Lee, to reinstate the $250 civil penalty. Any other discussion? All in favor say aye. Aye. Any opposed? Motion carries. Thank you, Mr. Bryant and Mr. Gribble.
Okay, sorry about that. The next complaint is complaint number 2024-050041. Complainant stated that their mother had already been buried in a cemetery and that she and his father had secured 4 burial plots in the cemetery. Complainant stated that they had made pre-arrangements with the funeral establishment that respondent worked at and that his father passed away on September 28th, 2024, and that his father was supposed to be buried beside his mother, quote, in front of the gravestone that was already on the grave, end quote. Complainant stated that respondent was the funeral director in charge, quote, over the service and burial, end quote. Complainant stated that unbeknownst to them, their parents' gravestone was placed over the head of his mother's casket and that the funeral home discovered there wasn't enough room to fit complainant's father next to his mother in the burial plot due to the distance between their headstone and a separate stone at the foot of their plot. Complainant stated that this was not mentioned to them prior to the digging of the grave that the funeral home dug the grave 67 inches from complainant's mother's casket to miss the headstone, rather than notifying complainant that the headstone should be moved. Complainant stated after the fact, respondent only informed complainant that his father was only a foot from his mother's casket, and complainant contends that if he had been told earlier, he would have just requested to have had the headstone moved. Complainant stated he contacted respondent to speak with him, and that respondent stated he had already talked to the graveyard caretaker. Complainant stated that respondent was rude during this conversation and would not let complainant ask questions. Complainant also said he contacted the caretaker, who advised that he was sorry and wished that there was something he could do. Respondent replied, stating that at 8 a.m. on August 31st, 2024, he went to the cemetery to meet the gravedigger to open the grave for complainant's father. Respondent stated that when he arrived at the cemetery, he noticed that his monument was too close to the row in front where a separate tombstone was located. Respondent stated they measured and only had 84 inches in between the two stones. At 8:20, respondent contacted the caretaker and told him that the monument was sitting on top of his grave and that they did not have enough room to set up the equipment for burial. Respondent stated they asked the caretaker if they, quote, wanted to have the monument moved, quote, and the caretaker said no. Respondent stated that they were told by the caretaker to, quote, move the grave south, but stay as close to the monument as possible to have room to set up, end quote. Respondent stated they did exactly as they were told to do. Respondent stated they returned to the funeral home and that upon his return, he informed complainant that his parents' monument was sitting on top of their graves and that they had been instructed by the caretaker to move the graves south to give them enough room to set up their equipment. Respondent stated it was his impression that complainant understood and that following the funeral service and burial, everything appeared to be okay. However, later that afternoon at 3:30, the caretaker called respondent and told him that complainant was upset, to which respondent told the caretaker to have the complainant call him. Respondent stated he spoke with complainant at approximately 4 p.m. and told that the complainant stated he didn't like where his dad was buried. Respondent replied that he had told complainant that they had followed what the caretaker instructed them to do because of the way the monument was set. After complainant was not satisfied, complainant recommended that complainant ask the monument company to reset the monument and move it south so it would be closer to his dad's grave. Respondent denied being rude or unprofessional. Respondent stated to close the conversation, complainant began asking cemetery questions such as why those lots had been sold to them and why the row of graves were out of place. Respondent stated they informed complainant those were cemetery matters that should be addressed with the caretaker, and then complainant hung up. Respondent stated they had not spoken to complainant since that day and that they simply followed what the cemetery told them to do. Respondent also included a letter from the caretaker of the cemetery. The caretaker confirmed that on the day of the funeral and burial, he received a call from respondent advising of the issue with the plot. The caretaker explained that in 2023, complainant's mother had been buried in the northernmost plot of the 4 plots purchased by the family. When the monument company placed the headstone, they had set it too far east, quote, practically on top of the head end of her casket, end quote. The caretaker explained this left too little space for complainant's father's burial. In a conversation with the respondent, the caretaker determined that their only solution was to dig the grave at the headstone's end and have the monument company center the stone above the 2 plots when they engraved the date of the decedent's passing. The caretaker admits that when discussing this matter by phone, he did not fully understand how far apart complainant's mother and father would actually be. Later that afternoon, while at the cemetery, the caretaker realized that the distance between the 2 plots was larger than anticipated. The caretaker stated he apologized to complainant and tried to explain the earlier conversation with the respondent and what led them to the decision. The caretaker stated that following this conversation, he advised complainant to contact respondent. On September 19, 2024, respondent and the caretaker met at the cemetery to discuss how to resolve the issue. The caretaker did not state what this resolution was, but stated that after they advised complainant of their proposed solution, complainant seemed relieved to know that it would soon be resolved. Legal spoke with complainant on October 31st, 2024, and confirmed that a resolution had occurred. Complainant explained that they, the funeral home, cemetery, and himself were able to successfully move the decedent over to be consistent with his plot. Complainant stated during the phone call, quote, as long as things stay like they are now, I'm happy, end quote. Based on the above, would recommend a letter of warning in regards to the communication with the respondent and complainant that based on the information, it appears that respondent had that conversation with the complainant of, hey, there's a problem at the visitation, essentially the morning of, and that communication between the 2 parties could have perhaps been a little bit better.
Any questions? Is this another borderline cemetery issue?
This was one that got very close to cemetery. It seemed like on the kind of the respondent's go-to was I was essentially just following orders, what the cemetery caretaker told me. It kind of the matter of the way the plot was dug, where it was positioned, the marker, everything. There's certainly move over into cemetery issues. What the complainant seemed primarily upset with was what he alleged to be respondent being rude and short with him, and the just kind of the, I guess, nature of how the plot had been set and everything. So this is one that is very close with cemetery.
Was the family offered to come out and look at it before the grave was dug?
From my understanding from what was provided, no. That under respondent's timeline, he gets there at 8 a.m. the day of, sees that there's a problem. At 8:20, calls the caretaker and says, hey, we have a problem. Can we talk about how to fix this? And then later, let's see if he gives an exact time. I don't
The
believe.
8 o'clock was the day of the
Correct.
funeral.
Correct. And essentially chats with the caretaker for a little while, and then goes to the visitation, speaks to complaint, and says, "Hey, we have a problem. Here's what's happened. Here's what we did." And he says, from his understanding, complainant was okay with it, but then afterwards, when the equipment's gone and things have been kind of settling, at 3:30, the complainant reached out saying, "Hey, I'm not happy with this."
Any other comments, questions?
I'm just having a little bit of just a little problem. I guess you can interpret it either way that you want to, but I'm really trying to find what the funeral director actually did wrong, other than what the respondent said, he said, she said about, the treatment they got. I'm just having a hard time with a letter of warning that stays on your record. I don't know how this board would feel with maybe a letter of instruction or something like that. Unless somebody else sees something that I don't, that can help me.
And I sort of agree with Mr. Lee, because for those of us, and we all do it, we deal with cemeteries, and we go to cemeteries, we're bound by what the cemetery tells us. If that caretaker tells us you have to do this, we can't go in and tell the cemetery how to run their business, because if any of y'all have ever incurred this before, they tell you, you're the funeral director, we're the cemetery, you keep your nose out of our business. And I've been instructed to that before. So I agree with Chris. I'm not sure a letter of warning, but maybe a letter of instruction, because to me, I feel the funeral director's in between. He's the one that's caught in the middle. He's trying to do a burial, but yet he's got someone telling him at the cemetery, this is the way it is. We have a headstone, a monument company that placed the headstone evidently wrong. And so there's a little liability on that company for placing the headstone wrong. So I agree with Mr. Lee on that.
I don't, there's a lot of back and forth here on this, and I don't see where, it doesn't mention in this complaint, I don't think, it's very long, so I went back through it, that the cemetery the funeral home was in charge of where the headstone was placed. It sounds like this is a country cemetery, church cemetery, something like that, where it's just a caretaker, and, I make a motion that we change the recommendation to closure.
There is a motion on the floor to change from letter of warning to closure by Mr. Nash, a second by Mr. Naylor. Any other discussion?
Ms. Bryant, y'all have something you want to add before we vote on?
The only thing that I was going to add is that my understanding on the complaint is that Mr. Nash is 100% correct that it is a smaller cemetery. That, from my understanding, the funeral establishment was paid for the opening and closing of the grave. I do think when reading over this one, again, Mr. Nash, 100% correct, a lot of back and forth on this one. This is one that I could tell was very... talked about before, we have those cases that are very rich of you all are in the field, you know what being in that middle position, like Mr. Wheeler said, is. So, defer to you all's knowledge and experience and judgment on that. And so I know that was a long and tricky one, so I appreciate all of your information.
I still have an issue with, did the funeral director know long before the grave was dug that there was an issue?
And from their narrative, from what they say, they learned it at 8 a.m. the day of.
When the grave was dug?
So I guess I may be misunderstanding your question, and I
So the
apologize for that.
caretaker did not say to the funeral director, okay, we got an issue here. There's going to be 60-something inches, I think is what was originally said. But then when they got out there, it was 80-something. The funeral director, from what I'm hearing, did not know any of this until the day of the funeral, or day of the visitation.
From their narrative that they submitted, that is correct, yes.
Okay?
But the funeral home was not responsible for digging the grave. Like, we have our own grave diggers, and there's certain cemeteries, we dig our own graves in. But there's a lot of country cemeteries or church cemeteries we go to, they have their own grave diggers. And a lot of times, we'll have a burial on, like today at 1 o'clock, and we go out to do our setup, and we find the grave has collapsed in and everything. But we didn't know that, and no one told us. So that's my question. Did the funeral home dig the grave? Was it their grave diggers? Were they the responsible party for digging the grave? If so, they would have known the day before.
Would they have dug where the caretaker would have put a flag? I mean, you know what I mean? That's how we do
That's
the
usually
small
you
cemetery.
mark 4 flags, and we dig where you mark.
So it sounds to me, in reading this, that the initial issue is where the monument was placed. That it should have been centered between the two graves. So there really was no reason to move the graves. They should have just moved the monument after they dug it.
Okay, so wanted to make sure, didn't want to speak out of turn, and after a while, all these start to run together a little bit. So what we have on the contract, on the funeral contract as a cash advance item is the opening and closing of the grave and then a dirt removal charge as well. So again, that is on the statement of funeral goods and services contract for the funeral establishment.
In the complaint, it says that prior to the digging the grave, that the funeral home dug the grave 67 inches from complainant's mother, but later they found out it was more than 67 inches. So there is a motion on the floor by Mr. Nash, a second by Mr. Naylor, to change the recommendation of legal from letter of warning to closure. Any other comments? All in favor? Whoop.
It seems like that the board's feeling is that something should be done. So I will withdraw that motion.
I was satisfied to vote on that motion. It's what you made it.
I just,
Mr. Nash, if you withdraw your motion and the original conversation was letter of instruction, that is something that can be done.
I will withdraw my motion for closure and make a motion that letter of instruction.
There's a motion on the floor to withdraw the, let me make sure I'm doing this Robert's rule, to withdraw the motion.
We never voted.
Yeah, so
We never voted.
correct. So I believe since I would rather be safe than sorry with Robert's Rules of Order, so I believe with Mr. Lee's second on the motion, we would need a motion.
Mr. Naylor's second.
He seconded Mr. Nash's motion.
Okay.
To close.
If whoever made the second for the motion for closure, if they withdraw their second, then we don't need to vote on the withdrawal of the motion.
It was Mr. Naylor. I wrote it down. Yeah. Okay, so according to my notes, Mr. Nash made the original. Mr. Naylor second. Mr. Nash is withdrawing his motion. Mr. Naylor?
I stand with my second.
So with the second of the motion for closure still being on the table, we do the Mr. Nash's motion is not withdrawn, and we do need a vote on the closure.
Okay, so there's a motion on the floor, a second for closure. All in favor say aye.
Aye.
Any opposed? No. So 4 noes, is that correct? What? Call the roll, Ms. Bohannon.
Don Haynes. Don Haynes.
No.
Chris Lee.
Yes.
Randy Nash.
No.
Wendell Naylor.
Yes.
Pam Stevens.
No.
Tim Willer.
No.
Ms. President, we have 4 noes and 2 yes, so
I
the
counted
motion is
5
withdrawn.
noes. Wait a minute, I may be wrong. 4? Got it. Okay.
Okay.
The motion to have the recommendation changed to closure is not passed. Okay. So there is a motion on the floor possibly for another recommendation. And who would make that motion?
I'll make the motion, we go back to council's recommendation and let's do a letter of warning. Since the funeral home was responsible for digging the grave, we've ascertained that, and they would have known the day before where that grave was located and how bad it was off from where it should have been.
There's a motion on the floor to go back to legal's original recommendation of letter of warning. Do I hear a second?
Second.
Mr. Haynes, second. Any other discussion? All in favor, say aye. Aye. Any opposed?
No.
No.
Oh, Lord. Okay, Ms. Bohannon, could you do a roll call, please?
Don Haynes.
Yes.
Chris Lee.
No.
Randy Nash.
No.
Wendell Naylor.
No.
Pam Stevens.
Yes.
Tim Willer.
Yes.
Oh, gosh. Okay.
So the motion fails due to a tie.
Okay. Mr. Bryant.
Yes, Madam President. At this point, happy to answer any questions that anyone may have. I'm just more troubleshooting with you all at this point. What could be an option is, I think, a happy medium in between a closure and a letter of warning could be a letter of instruction. That's an option. If there's more discussion to be had or any questions, I'm happy to help and facilitate that as best I can. Just let me know what I can do to help you.
If it's okay with the board members, I was going to say what Mr. Bryant brought up. Closure's out and warning is out. Instruction, I can feel comfortable with because that doesn't really penalize the funeral director, but also it makes them aware of what needed to be done or should be done next time. Is there any other discussion before I make a motion?
Do I hear a motion?
Madam President, I'll make a motion that we go with the letter of instruction.
Second.
There is a motion on the floor for recommendation to be letter of instruction. Motion by Mr. Lee, a second by Mr. Wheeler. Any other discussion? All in favor say aye. Aye. Any opposed?
No.
And we have a no vote. Okay, thank you. Thank you, Mr. Bryant.
Thank you all. The next complaint is complaint number 20240408881. Complainant stated that on May 25th, 2024, they paid in full for funeral services, but claimed that they were not completed as promised. Specifically, complainant alleged that the decedent was not groomed properly and was put in dirty clothes, and that the decedent's hair and face were not groomed, and that the vehicles for the funeral home had expired car tags. Complaint also stated that as of July 21st, 2024, respondent had not signed for their son's death certificate. Respondent replied stating that complainant's complaint is, quote, exaggerated and far from the truth, end quote. Respondent claimed that complainant had been disrespectful and unwilling to work with the funeral home and stated that, quote, the matter at hand is and will be handled in the appropriate manner, and this complaint is not true by the least bit, end quote. Complainant provided photographs to show that respondent's vehicles had expired tags at the time of the service, but did not provide photographs of the decedent's clothes or lack of grooming. Respondent did not respond to the complaint within the time required by applicable rules, and based on the above, we would recommend a $2,000 civil penalty authorized via consent order and a formal hearing if necessary.
Mr. Bryan, I have a question. It appears 2 months had slipped by and they did not have a signed death certificate. Has the family received a death certificate yet as of date?
When I spoke to the complainant, I essentially went through with them and just tried to do a checklist. When I spoke to complainant, I actually did not get an answer on that as to whether that was still outstanding, and tried to get back in touch with them to confirm that, and unfortunately, just kind of lost time in the week and didn't hear back yet. So unfortunately, I don't know the answer to that.
Any other questions, comments?
I make a motion to approve council recommendation.
Second.
There's a motion on the floor by Mr. Nash, a second by Mr. Wheeler. Any other discussion? All in favor say aye. Aye. Any opposed? Thank you. Motion carried.
Next complaint is complaint number 2024049241. Complainant stated that they originally met with respondent on August 19th, informing him of their mother's wishes to be cremated. Complainant stated that they agreed that there would be no funeral, but that they did want programs and to receive the cremains once the decedent had been cremated. Complainant stated they met with respondent again on August 22nd and that the price was paid in full. Complainant stated that as of the date of their complaint, September 4th, 2024, they had not received the programs or cremains. Complainant claimed that respondent offered as an explanation that they were waiting for the doctor to sign the death certificate, but complainant claimed that they had already spoken to the doctor, who had stated that they had signed off on the certificate on August 21st, 2024, which respondent denied that the doctor had. Complainant spoke to respondent again on August 29th, and complainant claims that they were told by respondent that, quote, the person that takes care of getting the death certificates sent off likes to wait until he has several death certificates before he turns any into the state, end quote. But respondent offered to get the death certificate to the complainant the following day. Complainant did receive the death certificate on August 30th, the following day. Complainant stated that as of the date of their complaint, they have yet to receive the decedent's ashes. Respondent replied stating that over the years their staff has diminished and that this has affected the manner in which they must conduct business so as to efficiently operate. Respondent confirmed that they met with complainant and that they discussed the final arrangements for the decedent, which included no funeral services, but a cremation and funeral programs. Respondent stated that the decedent was cremated as soon as all the proper documentation was obtained, but that because they are short-staffed, they are unable to make multiple trips to the health department for every death certificate and are unable to make trips to the crematory for every individual set of cremains. Respondent explains that this was not because complainant's mother's death certificate and ashes were not important, but that in order to operate efficiently, the trips are scheduled accordingly. Respondent stated that the delay for the programs was that they were not able to print them until they were approved by the complainant. Respondent stated that as of now, complainant has received the ashes and programs. Respondent closed their reply with, quote, we, the small staff of respondent establishment, do everything to take care of our families in their time of grief. Unfortunately, we were not able to accommodate complainant fast enough, end quote. Legal contacted complainant to confirm that she had received the ashes. Complainant stated that it was on or about September 23rd before the ashes had been received. During this conversation, complainant stated that respondent was not very responsive until complainant reached out. On the occasions that complainant reached out, respondent would usually follow up shortly thereafter with the requested service, providing the programs or the ashes, but that would usually take complainant following up to ensure that this happened. Based on the above, we would recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Any questions, comments?
Motion that we approve council's recommendation. Motion that we approve council recommendation.
There's a motion on the floor by Mr. Naylor,
Second.
second by Mr. Wheeler. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-048361. This case was administratively opened following a routine inspection conducted on August 15th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent establishment did not have adequate furnishings, including but not limited to chairs, tables, desks, and office supplies. On October 9th, the inspector followed up with the respondent establishment to determine whether the violations from the August 15th, 2024 inspection had been cured. However, when the inspector arrived, no one was present at the establishment, and the inspector called the manager, who indicated that he was out of town and would not be back until October 15th. The inspector informed the owner he would not return until October 15th to conduct the follow-up inspection, and the owner agreed. On August 11th, 2024, the inspector received a phone call from the owner informing that he was still out of town and would not return until October 16th, 2024 at around noon. The inspector agreed to this scheduled change. Again, however, respondent texted the inspector on October 15th, 2024, indicating he would not be back until October 17th, 2024. On October 15th, 2024, the inspector was working in close proximity to respondent establishment and stopped to see if any progress had been made. The inspector discovered a sign in the front window stating that it was for rent. The inspector spoke to the real estate broker and manager of the property, who indicated respondent had been evicted for non-payment. The investigator visited the local general sessions court and obtained a copy of the eviction judgment. Respondent replied stating that during the initial annual inspection, the furniture was not present due to theft and water damage caused by a plumbing issue. Respondent stated that the cleanup was extensive and done to prevent mold. Respondent further stated that the back windows to the establishment were broken out and their artwork, computer, sound system, bank records, money, funeral equipment, and personal items were all stolen. Respondent did not address the eviction notice from the building in the eviction judgment. It should be noted that during the August 2024 inspection, the respondent did not mention any water damage nor plumbing issues to the inspector, only that items had been stolen from the location. Respondent did not respond to the complaint within the time required by applicable rules. And a slight update to this next sentence. So as of November 8th, 2024, respondent had not submitted documentation to show that respondent had procured a new place of business. I actually, this morning, received a letter of a notice of intent that they have set something up, but we have made respondent aware that there are many more steps to go before we get there. So based on the above, we'd recommend a $3,500 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions?
Is this, so this was just a routine inspection. This was not, was this a re-inspection? Was this the one that we heard a few months ago?
This is not that location.
You know which one I'm talking about?
Yeah. The August one was a routine, had all those issues. I mean, the pictures from it were, there were no furniture, period. And so essentially, took the respondent at their word, said, hey, someone broke in, stole it. So did a follow-up inspection in early to mid-October to see if it had been cured. But no, this is not that establishment the board had.
Is this I don't know if you can get this descriptive in this or not, so just tell me no. Is this a funeral home with a chapel, or is this more of a office or storefront type business?
Let me just double check.
And I can follow up with the reason I'm asking if you want me to.
So, cannot say with 100% certainty. I am fairly certain it is a storefront-based establishment, but do not want to take that with a grain of salt. I don't want to tell you the wrong thing.
I understand. It's hard for me to believe that, all their furniture was stolen and then that just doesn't make sense to me. I make a motion, we accept council recommendation if there's no other discussion.
There's a motion on the floor by Mr. Nash,
Second.
second by Mr. Haynes. Any other comments? Questions?
My only question is, Mr. Brown, are they still operating? And if so, how are they operating if they've been evicted? And what is the state's position when a business is evicted out of their facility with their license as a establishment?
So the first question there is, we'll phrase it this way: do not have proof that they are still operating. If that proof ever comes forward, if we ever have any of that, I can guarantee you a complaint will be opened that day. And as far as, what happens when that occurs, what the position is, so much of the application process is linked to your location, your fixed place of business. And, we understand that things happen sometimes eviction, sometimes damage. Sometimes your brick and mortar location can't be your brick and mortar location anymore. And when that happens, as soon as possible, you need to understand that there's some kind of administrative steps that you have to take of not only notifying us, but things such as procuring new letters of parking, zoning, sewer compliance. A reinspection needs to be done to make sure that it's an appropriate space for a funeral establishment. All those things need to be done, and in the interim, you just simply can't operate without a fixed place of business. If something has happened to your old fixed place of business to where your only option is to procure a new one, you do not have a fixed place of business in order to be conducting license activity. So again, we understand things happen sometimes, but ultimately, you just have to have that location.
There's a motion on the floor by Mr. Nash, a second by Mr. Haynes, on the recommendation of the $3,500 civil penalty. All in favor, say aye. Aye. Any opposed? Motion carries.
All right, we're on the home stretch. These next ones are all together. They'll make sense in a little bit once I go through them. Next complaint is complaint number 2024050031. This complaint and complaint numbers 17 through 19 are all related and were all named respondents on the basis of the same complaint. Complainant alleged that between July 10th, 2020 and July 18th, 2020, respondent had, quote, routinely violated and or failed to comply with up to 12 different laws and regulations, end quote. Complainant stated that during this 9-day period, violations included up to 41 forged signatures on a funeral director by unlicensed personnel on official and vital records, such as funeral contracts, receipt of human remains, and cremation permits, unlicensed individuals engaging in funeral directing activities, inaccurate death certificates, charging families for embalming services that were never performed, and a lack of chain of custody for bodies in the care of respondent establishment. In addition to denying all allegations contained in the complaint, respondent, through counsel, explained that complainant had filed a lawsuit in circuit court on July 12, 2021, making the same allegations against respondent establishment and respondent individuals. Respondent stated an answer was filed in September of 2021, denying the allegations and any liability. Respondent explained that discovery and investigation has been ongoing for the last 3 years and is still continuing, and that a jury trial has been set in circuit court, originally scheduled for December 10, 2024, but now has been rescheduled for early 2025. Respondent's counsel also provided that the judge assigned to this matter had granted complainant's permission to meet with the Tennessee Board of Funeral Directors and Embalmers regarding the allegations in an April 4, 2023 order, and that only now, 17 months later, following an unsuccessful mediation in August of 2024, is complainant filing a complaint. Legal has spoken to counsel for both parties. Both parties have confirmed that the dates for jury trial that they received from the judge are between February and April of 2025. This litigation has been ongoing for well over 3 years. Given the history, discovery opportunity, and position of a jury to serve as a fact finder, it puts the board in a difficult position to potentially make findings of fact that may or may not conflict with facts found by the jury. Furthermore, given the significant discovery period and resources already invested, at this time, the circuit court is a far more suitable place for fact-finding to occur. Given that from the date this is being presented to the board, the parties are only 3 to 5 months from beginning trial, it is more appropriate for this matter to be litigated in front of the circuit court. So the recommendation based on that is closure with a custom closure letter to complainant that following the resolution of the matter in circuit court, they may file another complaint regarding these matters. The custom closure letter will include language specifying that the board is not closing this matter on the merits of the case and only due to the procedural and circumstantial nature of where the case currently exists on the circuit court's docket.
Any questions?
Madam President, I make the motion we accept council's recommendation.
There's a motion on the floor by Mr. Wheeler, a second by Mr. Naylor. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Complaint number 2024-09991. Respondent is one of the respondents associated with the preceding complaint. Complainant and respondent's responses were all identical, and thus my recommendation is identical to the preceding complaint.
Any questions for Mr. Bryant?
Motion to accept recommendation.
Second.
There's a motion on the floor by Mr. Nash, a second by Mr. Lee. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Complaint number 2024-050001. Respondent is one of the respondents associated with complaint number 14. Their responses and reply were identical, and my recommendation is identical to the preceding complaints.
Any other questions for Mr. Bryant?
Motion to accept. Second.
Got a motion by Mr. Lee, second by Mr. Wheeler. Any other discussion? All in favor, say aye. Aye. Any opposed?
And finally, last complaint is complaint number 2024-050011. Respondent is one of the respondents associated with complaint number 14. Complainant and complainant's response were identical, and thus my recommendation is identical to the preceding complaints.
Any questions for Mr. Bryant?
Second.
Motion on the floor by Mr. Nash, a second by Mr. Lee. Any other discussion? All in favor, say aye. Aye. Any opposed? Mr. Bryant, thank you so much for navigating us through that legal report. Mr. Gribble, we would entertain a report from you on the matters at hand.
Good morning. The first thing is a legislative update. Our office has not been officially contacted by either the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association regarding their intent to pursue new legislation during the upcoming legislative session that would affect this board. However, we extend an invitation to both associations and any other interested parties that would like to meet with their staff and legal counsel prior to introduction of legislative bills that would impact the board. License issued, you have a report of license that were administratively approved by the Executive Director pursuant to Board authority for the period of October 5, 2024 through November 5, 2024. Closed establishments, this time, first time I think we've had 3 in a long time. But we have 3 funeral establishments that have closed since the last board meeting. It's Bluff City Mortuary Services, 5270 Knight Arnold Road in Memphis. Coffee County Funeral Chapel, 786 McMinnville Highway, Manchester, and Dixon Funeral Home, Fairview Chapel, 1750 Fairview Boulevard, Fairview, Tennessee. Disciplinary actions. It's a report of consent orders that have been administratively accepted or approved by the Executive Director pursuant to Board authority, and as those that were reported on the September 2024 Regulatory Board Disciplinary Action Report. You have a list of those there as well. And lastly, the complaint numbers. As of November 6th, Ms. Bohannon tells me that there are 35 complaints that are open against funeral directors and or embalmers and 28 against establishments for a total of 63 complaints that have opened at this time. That's my report, Mr. President. I'll be glad to answer questions if you have questions.
Does anybody have any questions for Mr. Gribble? I'll entertain a motion to accept his director's report.
Motion to approve.
Thank you, Mr. Haynes. Mr. Haynes, motion, and Mr. Wheeler, second. Any other discussion? All in favor, say aye. Any opposed? Okay. At this time, Mr. Gribble, we have application, is that correct?
Yes, you have an establishment application for Blunt Funeral and Cremation. The proposed manager is Roger D. Jennings. It's to be located at 2730 U.S. Highway 411 South in Maryville, Tennessee. It's a new establishment or an application for an initial establishment license. Ownership is a limited liability company. The owners are Blunt Funeral and Cremation LLC, located at that address. I think there's a representative from the establishment present today to address the board.
Good morning. I think it's still morning, right? Yeah. Yeah.
Roger couldn't be here today. He's
Okay.
recovering from bypass surgery.
Oh.
I'm his partner,
My goodness. And your name, please?
Christopher Klein.
Christopher Klein. Welcome to our meeting. And as you can tell, we listen to a lot of things that happen across the state of Tennessee, even though we don't know who the person is or the funeral establishment or where it is. We do have to listen to a lot of those legal complaints. So I know you all were patiently waiting, and we appreciate that.
I've watched a few of your meetings, so
Oh, okay, very
kind of got
good.
a feel for how it works.
Good, good. Does anybody have any questions for Mr. Klein?
Mr. Gribble, I'll just go ahead and ask, reasoning there before the board today, and that something could not be administratively done, so, and I noticed this was a re-inspection as well.
That is correct. The reason they're before the application is before the board is it's not what the board typically looks at as a traditional establishment. And the board has only given me authority in the past to approve applications that fall within the traditional establishment or an embalming service or something like that. These type applications are always before the board. There was an inspection, if I recall correctly, in August and a re-inspection then later where some additional work was done on the building. Maybe between those times, and Mr. Klein could answer that better, then there was maybe some
We built a
supplemental work.
chapel wall to separate our reception area from our chapel area. We built a wall. You should have those pictures. Okay.
And that's all been completed?
Yep.
Is it a wall or is it curtains?
It's a wall. We started with the curtains, and then after talking to the inspector, we decided to go ahead and build a wall. We put the soundproof curtains on the inside of the wall to help any soundproofing. The curtains that are purchased are soundproofing curtains for theaters, and so we ended up building a 2x4 wall, putting up plywood, barn doors, but then on the inside of the wall, I hung those curtains because we'd already had them, and it deadens any sound coming into the reception area.
So you have how tall are the ceilings? From
The
floor to-
ceilings, I believe, 10.5 to 11 foot. The wall is 9 foot. What it is the ducting for the air conditioning and heating go through. So see how you have a drop ceiling here? It kind of runs into the same thing. There's no drop ceiling in that facility.
Why not?
What?
Why
'Cause
not?
Why wasn't there? There just wasn't one when we went in, and we weren't actually going. We thought that the curtains, because we're mainly using churches for our services, we were going to have a small viewing chapel area, so we thought the curtains would work. But after talking to the inspector, we realized the curtains weren't going to work, so we went ahead and built that wall
That's the wall with the sliding.
with the
doors
sliding
all
barn
over.
doors. Yeah,
So,
that's mainly our viewing area.
I guess that's my question. Will there, thank you, I'm sorry. I'm guessing that's mainly my question. So at this location, when you say viewing area, there's quite
We have 48 chairs.
48 chairs?
Yep.
Now, what's your interpretation of viewing? Is this
Well,
like a visitation
it's a viewing in
or
small,
a
yeah, a
service
small
or-
visitation
Okay.
before we went over to the church.
Okay.
We're working with the Apostolic Church in the area and a couple other places that have offered their facility to use for larger services where we have hundreds of people. But if you just wanted a small visitation or just a small family viewing before a cremation, we wanted to have a private area to do that.
Okay, I am looking at this picture right here.
Yep.
Okay, and what you're explaining is that, what I'm hearing, I think I'm hearing what you're saying, is that there's curtains and
On the
here's,
opposite side of that wall.
but not from, okay, there's the curtains.
There you go.
Okay,
I just had them open so you could see the barn doors.
but sure, but not from the top of the 9 foot all the way up to the
All the way up, right.
ceiling. There's nothing there.
There's nothing there. What I did was, for sound testing, I put a person speaking, as a preacher would be speaking in the chapel area, went into the reception area to see what you could hear. In the chapel area, you can't hear anything. I guess it's because of those curtains from the reception area. If you're in the reception area, you can hear a muffled speech from the chapel area. So you can hear someone is speaking, but you can't hear exactly what they're saying. The TV that I have there, I kind of did the same thing. I turned the TV on to simulate someone speaking to see what you could hear. You could hear that there was a TV on, but you couldn't make out what they were saying.
I should have started this conversation by saying, each person that has stood in front of us, as you've seen on some of the other
Yeah.
meetings, we ask a lot of
Oh, yes,
questions.
yes.
Okay, we do, we have to. So why is there a dining room table in the chapel?
We're going for a home atmosphere. One of the services we're going to provide is we're going to go to their home to make funeral arrangements if they want. If they do not want to come to our facility, they never have to come to our facility. And so part of our pitch was, we'll come to your dining room, or you could come to ours. So we have 2 private arrangements areas kind of in that private area where we could close the barn doors, but we also have a private arrangement office, as you should have pictures of.
Okay?
But that's kind of come to our living room.
Okay. So here, in this picture.
Yep.
This is where some folks can sit.
Can sit or
they can
mingle.
make arrangements here.
Yep.
And then here, if somebody wants to view, there is an area for them to view. up
Yes,
here.
there should be another picture looking in the other direction,
Okay.
straight on to where
Right,
you're
right,
pointing.
and I did see that. But
Okay.
this one, as you can see, I did a little bit of research here.
Yep.
Or reviewing. So I've got maybe a alternative container or a eco pine or something here for them to view.
Yes.
You've got all glass windows right
Those
here.
have, it's like you've seen in TV shows where they're doing the investigators and the police are on one side. It's a one-way mirror there. You can't actually see in from the
Inside.
outside.
Okay,
We had those put up. We were going to do it across the whole front, but it made it so dark inside, we didn't put it in the reception area. So we paid to have that mirrored.
I can see it from this picture.
I don't have that picture. Let me see that, Randy. Oh, yeah, in the front.
Can you tell us a little bit about yourself and your partner?
Roger has been in the funeral business for 26 years. I've been in the funeral business for 11 now. I started working at a facility as the maintenance man. I had a GED, and I didn't want to do maintenance anymore. So I talked to the owners, and they let me start my apprenticeship. I went and took classes at Pellissippi, and kept going at Pellissippi and got an associate's at Pellissippi, and then went to John A. Gupton and got my license and associates while working at the funeral facility. Yep. I have a funeral director's embalmer's license. Roger's a licensed funeral director. Our idea is a personal touch. We want to, and things have moved to such factory. Now, our facility is small at this point. We hope to be able to grow into a bigger facility as the future goes, but we feel like it's moving more towards immediate cremation, and the personal touch between the people and their grieving has been lost.
Did you all work together? Is
Yes.
that how you know each other?
Yes.
Okay.
Yeah, we've worked together my entire career.
What is the total square footage of the
1,500 square feet.
1,500?
Yes.
Oh, wow. That is small.
So let me understand this correct. If
Wait.
you've got someone in your chapel area, and let's say it's full, all those chairs are full.
Yes.
And you've got a service going on with music,
Yes.
someone's singing live, something like that, but then in the other area, you have a visitation or a reception going on.
It's
You-
just a reception area. It's not like for.
So you're not equipped to handle two things at one time?
No, we wouldn't be having two services at one time.
Who will be doing, I saw Mike Harding. Does he have a funeral home?
Mike Harding has blunt mortuary services. Mike is going to allow me to do the embalming at his service, and then when there's times that I'm not able to, we will just use Mike's service.
I'm not familiar with Blunt Mortuary.
They have an establishment license. It's an embalming service in Maryville.
I know Mike, but I didn't know he had a mortuary service. I thought he was in the vault business. Oh. So this area, and I have a couple more questions about the area.
Okay.
I have a concern about the size and
Okay.
having that many people in there. This right here, what happens here?
That's
The
just
bar.
our reception area. Our secretary sits there.
Okay,
So if you came in the front doors, that's where you'd be greeted.
okay,
Behind that is our arrangement office,
okay,
and then going down that hallway are the bathrooms.
okay. I didn't see pictures of bathrooms. You do have men and women?
Men and women, 2 handicap bathrooms.
Okay. Okay. I have a question about the GPL. Let me find it, okay? Is it in the front, guys?
Yes.
Okay. Okay. And Chris, let me say this. I'm an old funeral director, old. So I am not familiar with green embalming.
Okay. You actually don't use any formaldehyde or glutaraldehyde. It's a special product that you order. They don't get put into a standard casket. It's more of a wicker casket.
Okay.
And it's so that everything's completely biodegradable.
Okay?
So they can actually be buried into, you know how some of those natural cemeteries that don't accept embalmed bodies, you
Right.
can actually bury in that cemetery if you've done a green embalming.
Are there green burials in Knoxville, that Maryville area?
Yes.
Okay. And then the other, as you can see, I've highlighted, so I have these questions prepared here. What is body donation with visitation? Is that like
When
Tennessee donors?
Tennessee donors, yes, and then the person before they want to cremate, they want to do usually a full viewing. They bring in clothes, they want them dressed and cosmetized, and they'll do a visitation or a viewing before the cremation and that's with a body donation.
I have a question for Mr. Gribble. On the letter J, is that an accepted description for the GPL, or is that up to the funeral home to?
I yield to council. My thinking is we see a lot of different, when you're offered, there are certain things that are required, and then, as you know, some of the items have to be very specific, and then others, there's some
Right,
wiggle
gray
room
area, right.
or freedom, and I take it as being that one being one where there's freedom. I mean, it's
Okay.
a service that they, as to what they call it, that's typically, we leave it to the funeral home.
Okay.
And I would agree with Mr. Gribble on that. I think in that instance, there's a little more, I guess, wiggle room for description.
Okay. It just jumped out at me, body donation, just, I was hoping there was a
So
more
I'm glad you asked that question because I had the same
subtle.
question. So let me clarify, make sure I'm understanding. So you say body donation, are you meaning like where they're going to donate the person to a like Genesis or let's say the Body Farm, something
Yes,
like that?
yes.
And then not a body
Not
that's
a-
had organ or tissue procurement. and
No,
then
no, no.
used.
They're
just said
sending
that
them
to me.
to the
Okay.
Body Farm or
All I heard was Tennessee Donor Services. I'm sorry. I thought that's what he said. So,
That's what he said.
okay.
So let's say that I'm a body donation. My family is selecting body donation with visitation. I am donating my eyes, my heart, my whatever. Is that what you mean?
no,
There's
no.
not-
It's when they're donating the body to science.
There's not a body present.
No, there is a body present, and usually in those cases, there can't be any preparation done on them. Because when we send them to the Body Farm, you can't even sew their mouths closed.
So are you saying you have an unembalmed body available for public viewing?
Not public, no, no.
Okay, that's what I thought.
It says visitation.
Private visitation.
We
for
don't have a
family.
body farm in Nashville. and
Oh,
I'm not-
okay.
I'm not, you,
How long's your private visitation exist, time-wise?
We have not actually set a time limit on anyone. I mean, if somebody wants a private visitation for an hour and a half or 2 hours, 3 hours, we're not trying to,
So let me ask this question. So you have someone who dies of, let's say, cirrhosis of the liver or liver failure, kidney failure. For those of us that are embalmers, we know exactly
yes.
deceased is full of edema, their stomach is extremely distended and all. Usually you have purge, stuff like that. And you're gonna put this body out for private family viewing? How are you gonna handle that? That's my question.
Usually with plastics. I've been doing it at the facility that I've worked at for years. They don't tell people no. And so in those cases, that is tough. You are allowed to aspirate. We're just not allowed to add to. So I wasn't allowed to sew or put eye caps in. So I did things like with clothes, I would keep their mouths closed. If someone's body is so far gone with edema, like you're describing, where there's just unviewable, we talk to the family. We kind of recommend, this is not necessarily what you want to move forward with. But if somebody wants to see their loved one, I've never stopped them from seeing them. I just do my very best to make it a picture they'd want to remember and not something that's going to bother them or haunt them.
I personally have a problem with the description, and I have an issue with the staff and overhead. Have you seen this on other GPLs, and you've taken this verbiage from
Yes.
other GPLs?
Yeah, that's how-
I've never seen this. Staff and overhead.
Well, on here, he's saying that it's private, but it doesn't say that it's private. It says visitation memorial service. And so it doesn't say that it's private. So can, we have private put on there? Because those of us that's up here that are embalmers, you know, we do know things can, and funeral directors, things can get out of hand quick, fast, in a hurry. And what's the time frame that you have to have the body at the facility?
at the facility,
Yeah.
usually 72 hours.
Okay.
And a lot of times they'll come from the body farm and pick them up. There's only been a couple of times that we've had to deliver them.
Okay.
To follow up with, and I hear what you guys are saying on that. But as we all know, it's not a requirement to view a body that it has to be embalmed, right? The one thing that I didn't, and maybe I missed it somewhere in here, what about refrigeration?
I have a refrigerator.
At your facility?
Yes. It's a two-body cooler. You should have a picture of it. If not, I have a picture here.
And is there a charge for that?
No,
I may have missed the picture. I don't see that in here.
did you not?
Is it in the garage area?
It is. It wasn't assembled when he was there.
Okay,
It
yeah,
was- We had
always-
ordered it, and he had took a picture of the cooler we ordered.
Yeah, all I see is just the garage, and there's like a white casket beer.
That's where it'll be. Oh, thank you.
Do Blunt Mortuary has a cooler?
They do not. Our crematory facility does. I brought pictures from our crematory facility. They have two coolers, and they're adding two more. I have a cooler like this one.
Can you bring that up?
Yeah.
Can you allowed to bring that up?
Yes, could you approach,
Can you approach the?
who's your crematory?
This is our crematory. Lee Heights Monument in Lenore City.
Caleb Wilson. Down by
Lee Heights
Lee Heights.
Monument?
It's crematory. They have the monument company and then they have the crematory also.
Are they a licensed establishment?
We use them.
I have a picture of my cooler.
So is this your cooler?
Nope, this is the crematory.
Crematory.
This is my cooler. And
And-
it is in the garage facility that you.
In this picture, right there?
Yep.
Yeah.
It is actually here right now,
Okay.
where I'm standing.
It sits right here. This is one of those ones where it sits on the concrete, it's the bottom.
Yeah.
One more question on the general price list. Event Center for Funeral Family Meals, is that in your facility?
It is located next door. It's an adult daycare facility, which we've worked out with the manager to use it in her off hours. Her hours are from 8 to 5, Monday through Friday. And she has an event center attached to it. So we've worked it out with her to rent that event center. It's maybe 100 yards away from our facility.
An event center that is a daycare?
It's an adult daycare.
Oh, adult daycare.
On the, well, just lost the picture. On the back, did you guys install that fence?
Yes.
You did?
Just my curiosity, do you know what this was before you took it over?
It's been a few different things.
I was trying to figure out the layout. It was just.
It was a pool place that sold pools for a while. Then it was a appliance store. And right before we had it, it was a daycare, an actual daycare.
Is that the Little Cub?
Little Cub Den. Behind that facility is actually 10 acres of undeveloped land, which I've kind of spoken to the owner. That's my future hope, to establish my foot in the door, build a business that I can then build a full funeral facility directly behind that.
So you're renting?
Yes,
This.
that is a rental space.
I will share with you my concern. It is the wall going from the floor to the ceiling. It is a big concern for me. And barn doors. when you're talking to the general public, maybe you could say sliding doors instead of barn doors.
What is your automotive equipment?
We have a hearse and a removal car, and we are looking for a lead car at the moment.
So none of those are in the pictures right now.
Oh, do you not have any pictures of those? Okay.
What is this little area right here?
It was just a little storage area they had, so that's what we were gonna use it for. A little storage space. There's curtains.
Curtains,
It's just,
right.
yeah.
Little kids love to peek behind curtains.
I did go back to Mr. Naylor's comment, and I agree with him completely on your GPL, where you state for the donation that it's a visitation. I think that should be private. I think the wording should be private.
Should say private
Because that
visitation.
would, if I read it the way I read it, that means anyone who can walk in should be able to be a part of that visitation. And I'm not sure you're going to put an unembalmed body for 2 hours that dies of hepatitis C or something like that out for 2 hours unembalmed. I have some concerns, health concerns over that.
Chris, at your previous employer, was that something that you guys did frequently because of the access to the body farm and things like that?
Regularly.
Because of the
Regularly.
geographically where you guys are?
Yeah.
Was it mostly body farm donation, or was it?
Majority body farm donations.
Okay. What, when you came across situations where the body had issues, what was your usual protocol? I know you said something about plastics and things like that, but
Yeah.
was there cases where you guys would advise against that for the families as well?
Yes, yes. And then the facility had come up with a letter to have them sign in the times that they insisted on still seeing
Sure.
the person.
Like a waiver or something like that?
Yeah.
And so what about, as far as that body donation, that private visitation, what would the decedent be placed in? What kind of container or receptacle?
We have a viewing table.
It would be a table, it wouldn't be
Yep.
like a
Ecopine.
eco-pine or some sort of other container or anything like that?
We offer those.
Sure.
But usually we always did those on the viewing tables.
Okay.
They were set up with blankets and pillows, and it's a full viewing table.
Sure. And did families generally use that as a private time, or did they usually allow the public?
Usually it was always a private time.
Okay. I would,
But there was we never stopped anyone. So there were times that people would show up with 30 people, and we never turned anyone away.
sure. So I guess what you're saying is it's a thing that it's an I don't want to say accepted practice, but it's a common thing in your area, in your service area, for other funeral homes in Maryville or surrounding areas that offer that service.
Yes. They have offered that for the entire time I've worked at
Sure.
the previous employer.
And the churches that you guys have the ability to use, the Apostolic Church, I think.
Yes.
Do you have any kind of written agreement with them, or any kind of anything that?
Not in writing.
Okay.
The
But you have a relationship with them previously,
Yes,
and
very close.
what? So when you get a death call, whenever it may be, let's say you know that. I'm guessing, coming from a person who's started working for themselves, that you're going to be doing a lot of the removals and transfers yourself at the beginning.
Yes.
Are you going to transport them usually to your cooler first at your facility, or to Blunt Mortuary Service?
I've kind of walked through that just through myself.
Yeah.
If I can find out if I have permission to embalm or not, I will go directly to Blunt Mortuary Service
Right.
and do the embalming myself.
Right.
And then bring them back to my cooler. If it was a cremation or I didn't know, yes, I would take them back to my facility, put them in the cooler till I could
So
determine
that brings
what
me
the.
that brings me to my next question. So when you said that you would embalm them and then bring them to the facility where the cooler is, so does that mean you're planning on doing dressing, casketing, cosmetizing at your facility or at
Yes.
Blunt?
Where would that be done?
In the back where the cooler is, in that garage space between.
garage.
It's
This one?
it's actually the back room office space where the desk is.
So,
There is no garage at the facility.
Mr. Bryant, Mr. Gribble, I think we might need some clarification on what the rule reads on that. As far as where the dressing, casketing, cosmetizing can take place, if it has to be in a establishment with a embalming room or not. Not, and Chris, don't take this as me questioning that you're doing something wrong. I'm just
No,
trying.
no, I was gonna say also, I mean, I can always dress them
Yeah,
at the
I
facility.
mean, I want to make sure, I just want to make sure that if, you know, we, yeah, we're within what's, you know, statutorily what you can do.
So I think Mr. Gribble and I are on the same page of this. I think in this instance, it would probably, if anything, fall more under that rule regarding professional conduct about that can be a very wide and sometimes all-encompassing rule. And it more just comes down to the situation of if a family was in that facility and had that space, you know, some may be totally fine with it and no issue whatsoever. Others may have reservations and concerns. And I think from there, that's the rule, if I were to pick one, that if there were to pop up an issue via a formal complaint or something like that, that's probably the rule that it would most likely come from, would be my guess.
So,
So, once the family's loved one is prepared, they're taken back to your facility. Would the casket be delivered there at your facility?
Yes.
And you do the actual dressing and that sort of thing? What if
Personalized.
something occurred from point A to point B, and, because that happens.
Re-aspiration or something like
Happens
that.
a
Yeah, okay.
lot. So how would that be handled?
I would have to go back to the embalming facility.
how far apart is your facility from?
5 minutes,
5 minutes.
yes.
From mortuary?
From Mike's, yeah.
Right. While you're thinking, Randy, Mr. Nash, there won't be any casket selection room, or you're going to do this via,
At this point in time, everything is on laptop, because like I said, our intention is to go to the people's homes. Well, all of the people that we've been discussed, like, different ideas with, thought that it was a great idea to offer, we'll come to you. We're gonna come to you and do the removal usually at your home. At that point, we'll offer, if you would like, we will come back tomorrow and make arrangements right here with you, instead of you having to come to us. So that's why we set everything up on laptops at this point. And those TVs you see in the facility, everything can be put onto those TVs for display. So if we were showing caskets or anything, they can be shown on that screen.
I want to make this comment. Not only does this board try to follow the rules of the law for funeral directors across the state, it is our position and our responsibility to protect the consumer as well. So with that said, does anybody have any other questions for Mr. Klein?
No, Mr. Gribble, And everything checks out okay, all this paperwork. We don't have any issues.
Sorry, I know you asked Mr. Ripple, but I'll jump in real quick. Sorry, Mr. Naylor. One thing I think, so as far as the inspection paperwork, that's the first several pages of your document there. To my knowledge, everything on that came back okay. We're not violating, the establishment's not violating rules or statutes based on everything in a normal walkthrough. One thing I think could be a fair ask on, we start getting into those rules that are a little less black and white in the sense of, you know, your general price list must include this. That's easy to follow. That's easy to know if you're there or not. Things like things that may be unintentionally or intentionally misleading to the general public, things like that. I think the board brought up a good point here, and I'm sure Mr. Klein would agree it was not an intentional matter, but something to the effect of on that GPL, maybe adding the language on the body donation that it is a private visitation. And it's something that, again, things like that, just so the public can make as informed a decision as possible. I think a change like that could help those more gray areas where something may fall in. Just notes from the board on things like that can be amended to where we get there.
One other thing, I'll say that it's my understanding that there would not be any preparation work done at this facility, because when the inspector did his inspection on September 23, if you go to the page at Roman numeral 5, preparation room is totally marked through. It was my understanding that it was the embalming preparation was going to be done by the mortuary service. That included all things that the body that came to the facility would be enclosed in a container of some type.
And that can be accomplished without any issue. I prefer to do the things myself, just because I know how I like things, but I have no problem allowing Mike at the mortuary service to do all body preparation and then just bringing the body to my facility.
I don't think that's what we're asking.
Oh, okay.
I think we're asking that everything be done at the mortuary by whomever, whether it's you or Mike or Mr. Harding or whomever. But
Yeah.
am I correct in saying that?
You are. I think what Mr. Gribble alluded to by the inspector being there was when that deceased person entered your facility, if they were having a traditional service, it would already be
They need
casketed.
to be casketed. Okay.
Yeah, everything, dressing, cosmetizing, and all would take place at this
At
other
Blunt Mortuary
facility.
Services.
Nothing was to be done there. And upon looking at the application, it is completely struck through, which means nothing can be done there.
Okay.
One other question, because and Mr. Bryant can tell you I'm a proofreader. Under embalming, why is the E in a parentheses?
I don't know. It might be a typographical error.
I think it's a typo. Just wanted to let you know.
Okay.
Oh, I see it, yes.
I think that is what that was.
Yeah, yeah. So our recommendation is on J, that there be verbiage added, or?
I think on J, on the body with donation with visitation or memorial service, I think that would need to be amended to say private. But
Is the
But
memorial
at the
service
end,
gonna be private?
but at the end of the day, and case in point, too, state law and statutes don't require that embalming take place for any kind of viewing. So, I mean, we may not, it may be a facilities policy, you know, to have embalming prior to a public viewing, but they may not be as well. So I don't think that, I don't think that's necessarily a requirement, especially that's not one of the, that's an additional thing. That's not one of the, the FTC requirements on the GPL. So I don't know that we have to, or that we can. There,
Again, we're protecting the consumer.
right, I understand, I agree, I just,
Are you all gonna have traditional services as well, right?
Yes.
Mr. Nash brings up a great point.
Which point was that one?
About not having, yeah, that is true. Not requiring private to be there. Mr. Chris, I tell you, it's the only thing that and I feel sure is probably have something to do with your landlord, to where they wouldn't let you take the wall all the way up to to the cellar and stuff. And it is what that'll be what it'll be. Going by what you're telling us, and we'll have to trust you. And of course, if you should do anything wrong, and somebody file a complaint, then you come back before us.
Before you.
Then we're gonna have fun with you, okay? And so we take you as you were. But Madam President, I go ahead and make a motion that we approve his application.
There's a motion on the floor by Mr. Naylor,
Second.
a second by Mr. Lee. I will continue my remarks that I do have a concern about the sound. A lot of the storefronts that are brought before us do not have public services there. And I'm not saying this is a storefront, I'm just saying that it's, in my opinion, and it's personal opinion, that it's, I have a concern that the consumer may not know that until they're there for the service. So there is a motion on the floor by Mr. Naylor, a second by Mr. Lee. Any other discussion?
Madam President, just
Yes.
so we are on cue too, that we understand, no preparation of any type will take place at this facility, that it must be done at the Blunt facility. I want to be sure we clarify that.
Mr. Naylor, is that part of your motion?
Yes, ma'am.
It's part of your motion. A second by Mr. Lee. All in favor, say aye. Any opposed? Aye.
And would like to add just to Mr. Wheeler's point that under 62.5.313 subsection B2, it does state that each funeral establishment must have available for its use a preparation room equipped with tile, cement or composition floor, necessary drainage and ventilation, and necessary instruments and supplies for the preparation of embalming dead human bodies for burial, transportation, or other disposition. So at the end of the day, if all those boxes on that aren't checked, then yes, the preparation must be conducted elsewhere.
Okay.
Madam President?
Yes.
One thing for clarification.
Yes.
Before a license is issued, we need a revised general price list that says private, is that?
No, sir, we don't have to revise. That was not in my motion. That's not in my motion.
I wanted to make sure I understood.
I think the only thing that need to be revised would be I think the only revision would be on that letter.
The
E.
E
No,
in
the
the parentheses.
the E in parentheses, but on the, I mean in the preparation letter.
What do you mean preparatory?
From Blunt.
The
From
letter
Mike
from
Harding?
Blunt, from Mike Harding, that says that embalming, casketing, cosmetizing, all those things will take place at Blunt Mortuary.
Let me look at Mike's letter. It's, but it says other services are needed by the funeral home. Does that fall in?
I guess that does, yeah, sorry.
Does that fall under it? Is everybody,
I flipped through it so many times I can't remember what it said.
okay. Thank you, Mr. Klein. And we don't want to discourage businesses, but we want to encourage that we don't have to go before legal.
Thank you.
Uh-huh, you're welcome. There are no other applicants or establishments that we need to talk about. Okay. So at this time, we'll move into our election of officers for 2025. We have 2 positions available. Chris Lee has been serving as vice president in 24-25, and I would like to make a motion that Chris Lee's name be presented as president to start the 2025 year.
Second.
So I've made the motion, and Mr. Nash has second. Any other discussion? I hope not. All in favor, say aye.
Aye.
Any opposed? Okay.
Thank you.
Congratulations, Chris, and we'll be hearing more from you in the days to come. At this time, I'll entertain a motion for vice president.
Madam President, last month I put my name or submitted my name in. I would like to remove it just to the fact I have a few personal things I'm trying to take care of, and I think it'd be best at this time.
Thank you, Mr. Wheeler, but we hope that you will consider again in the future. Do we have a motion for vice president?
I'd like to make a motion to nominate Mr. Wendell Naylor for vice president for the 2025-year term.
I'll second.
Motion by Mr. Lee, a second by Mr. Nash. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Okay. Notice I'm not giving y'all much time for discussion there, so.
There's a ball game.
So, also, we have a board appointment for 2025. We need a motion for that person, or if we, no, we do need a motion.
We do.
Okay. So I'll entertain a motion for,
For Mr. Haynes as
Mr.
our
Haynes.
continuing education liaison for the year 2025.
okay? And Mr. Haynes, you'll take on that responsibility?
Why are you looking at me funny? I'll second it, the rest of it.
That's right. So we got a motion on the floor by Mr. Lee, a second by Mr. Nash. Any other discussion? Thank you, Mr. Haynes. All in favor, say aye.
Aye.
Any opposed? Okay, congratulations to Chris Lee, to Mr. Naylor, and to Mr. Haynes. New business, Mr. Gribble.
Yes, there are 2 things. First, and they both pertain to the International Funeral Service Examining Boards. First is a report from Mr. Wheeler regarding his attendance at the 2024 Regulatory Board Service Workshop.
I have only like a 55-minute
gosh.
presentation,
Mr. Wheeler.
but I'm cutting it down really quick, okay? I've got to drive home. No, I want to say this was probably one of the best conferences I'd ever attended. They addressed a lot of things. They gave us this booklet, and there's a few things I would like to express to the board, which would have been nice. Our consumer advocate, one thing they talked about was board participation, and they asked the board members, how about your consumer advocate? How often did they attend your board meetings and all? And so they addressed to us that it was up to the remaining board members to make them feel at home, educate them on what they are, because they are stepping in as a consumer, and they know very little about this industry. And they were just bringing up that most of us said we had maybe even met. Some of the board members said they didn't even know who their consumer person was. So that's something I think, we need to look at as a board, that whoever it is, we need to make them feel welcome and all, and try and educate them in it. The second thing they discussed, and this was something I didn't know, we as board members, the governor only appoints us to 1 4-year term, and then your term expires and that's it. So like the conference has people from across the country from other state boards that sits on their boards. And because our board is only a 4-year term, it automatically bumps us out of even being able to serve on the funeral conference examining board. So this sort of, to Mr. Bryant, that is something they said as a state board, we need to look at, that the governor can do a second 4-year appointment consecutive, and that would then open our state to be able to serve on the board of the conference. So that is something, and then they discussed a lot about trying to get all states to be more uniform in their language and state laws, that it would just be better. I will say it was a full day. It was wonderful, beautiful place. I met some of the nicest people you could ever meet and feel I made some friends across the country. So anyone who gets a chance needs to go. It's well worth it.
Okay. Thank you, Mr. Wheeler, for representing us here, and thank you for that brief report. We appreciate it. Mr. Gribble.
That dovetails into the next item. And I will say that Mr. Berry, Fred Berry, who was on this board, Mr. Wendell Naylor, and now Mr. Wheeler have all attended this training or workshop at different times. And so there's possibly an opportunity in 2025. This would be the annual meeting, and also the workshop is contained therein. It's February 25 through 27, 2025, and it's in Palm Springs, California. And what begins the process is the board could select one of their own, could select a staff member or an attorney, or the attorney, and then that starts the process. But everything has to be submitted to administration, and it has to be approved by administration before the person can go.
Is that something that we appoint today, or somebody needs, if someone has a interest, to get back with you?
It would be good if you could select someone today, because the process, as we found out with Mr. Wheeler when he and I went to this recent one, it's become a longer process than what it was earlier in order to get approved going through all the, there's been an added step, and it takes a little bit longer.
There's a lot of hoops to jump through.
Too quick, Tim. You think you gotta go Palm Springs?
If
I'll go, though.
if the board's not ready, I mean, we could wait till December. If the board's ready, today would be good.
Does anybody have an inkling to want to go, or I have a prior, so I definitely cannot, and I'm not that far ahead, but I wanted to see. If not, then
I would love to go, but I've got something already planned that I would leave on March the 2nd.
Mr. Naylor?
Mr. Naylor.
Is that call for a vote?
I make a motion.
Motion's on the floor by Mr. Nash. Do I hear a second? Second. Second by Mr. Haynes. Any other discussion? Dr. Bass? All in favor, say aye. Aye. Any opposed? Ms. Bohannon?
I'm sorry, I didn't hear you.
Do we have to do the staff person as well?
We nominate.
Do we nominate the staff person? You select that?
There's a possibility of sending 2 people. I will be there because I'm a member of the board
Right.
of the conference.
Right.
As far as Ms. Bohannon, it would not be prudent for she and I both to be going at the same time. So I go off. This will be my last meeting with the conference as a board meeting.
Yes, sir.
As a board member, so maybe in the future, I would suggest you might consider her. And the attorney is also, can be considered. And there's a possibility of having 2 to go, but it would be my thinking, it's much easier to get 1 approved
Sure.
than it is to get 2, based especially on the last submissions and approval.
Yes, sir.
Was there anyone that signed for public comments?
Sorry.
Okay. I'd like to read, the department encourages public comments in open meetings through various avenues and welcomes healthy debate and the expression of diverse opinions. If you do have anything that you would like to reach out to the department, feel free to do so. Is there anyone in the audience that has any public comments that you have not signed up for at this time? We appreciate our guests being here and enduring this long meeting. But we also appreciate Mr. Bryant for everything that you do, and Mr. Gribble and Ms. Bohannon. And to all the board members, our next meeting is December 10th. Here, I will entertain a motion for adjournment. Oh, wait. we
Sorry,
have-
very quick. I do just want to make the board aware, currently as it stands, we are scheduled to have a hearing at the next, a formal hearing at the next board meeting. I will tell you, if things may settle before then, stranger things have happened. I do anticipate that it will go forward, and I will caution the board if you thought this one was a long meeting, that it is shaping up, I think, to be a pretty long meeting. So definitely eat a big breakfast. And then obviously we can, during the middle of the day, we can stop and have recess. You're not trapped here, but did want to make the board aware of that, just to know that that is on the docket for next month.
So I have not ever sat through a court hearing, and I don't know, has any of the other board members sat?
Yeah, with city,
Through this board?
not this one.
Okay.
So I guess the way, kind of the metaphor I've used before is there will be an administrative law judge here. They will be presiding. So issues like can evidence get admissed, things like that, the judge will handle that. Essentially, the board will operate in the role like a jury would. The board will have an opportunity after the direct and cross-examination of a witness to ask their own questions if they have them. If something wasn't addressed during the direct or cross, you're more than welcome to ask the witness anything at that point as well. I guess, do you have any specific questions on it, or?
Will our regular meeting take place first and then the hearing, or hearing first and then our regular meeting?
My suggestion would be if the hearing goes forward, that you not do your normal business, that was why we talked about, having the
Right.
elections and everything today.
Right.
If the hearing goes forward, then that would probably consume the day or the majority of the day. If it doesn't go forward and there's a business need, then I will obviously confer
Right.
with you and legal.
Right.
But if there's business need, then have the board meeting. If the matter settles and there's no hearing, then there may not be a need to have a board meeting in
Right.
December.
Is this a case that we as in this board heard this year, and or is this a previous case from other years?
So it was actually at the board meeting exactly 12 months ago that this board heard this matter. I believe that was Mr. Naylor's first board meeting. So it is exactly 1 year ago it was first presented to the board. We have been working for many, many months to come to resolution. It was this matter was filed back in August, and with I know the courts have very busy dockets, so December was kind of the first we could get to it.
In those cases of these hearings, is that something that since some of us weren't on that board, do we get to review things beforehand, or was it just everything's presented that day?
So my understanding is everything's presented that day. Essentially, what my first, I'll avoid saying specifics because I can't imagine that would get objected to, but you never know. My intent will be to the document that was used as the filing document should be made available, so you're not just coming in completely blank,
Sure.
No idea what it's going to be about or anything like that. And typically, barring any circumstances I wouldn't be familiar with, the parties would be afforded an opportunity for opening statements, and so I will, during mine, distill that down as much as I possibly can and kind of line everything out.
I don't know if this is a question ahead of time, but Is there anyone on this board that would have to recuse themselves from this trial or court?
Possibly. That's probably the worst answer since it's not very definitive. But I'm going to follow up with my supervisor, let them know kind of where I think we are and if it's necessary. I think when it comes to recusals, I'm always try and just be safe rather than sorry. But if it's something where we can move forward with everyone, then we definitely will.
Okay, thank you.
I will mention that I mentioned to Mr. Ports this morning when he and I communicated that there's a formal hearing scheduled for next month, and it would be very good if the consumer board member could be present. And he indicated to me that he would make every effort he could, and that he would notify his staff ahead of time that he needed to be here that day.
Very good. May I entertain a motion to adjourn?
So moved.
Mr. Nash? Somebody second, Mr. Lee. All in favor, say aye. Aye. Any opposed? Thank you. And thanks again for you all to be here. Thank you.